Hello everyone. Welcome to today's video. In this case, we are looking at a person in a court proceeding who chooses to speak for himself instead of having a lawyer. He believes that some official rules, like getting a driving license and insurance, do not match his personal or religious views. Today is an important stage because it is the final pretrial before the main jury hearing. This means the court is preparing to move forward and reach a final decision soon. In this video, we will observe how the situation develops in court and how the process continues step by step in a clear and simple way. Everything is explained in easy English for better understanding.
3-0. Good morning.
Happy New Year.
Happy New Year. We're set for a pretrial readiness date. Are you ready for trial on the 15th?
I am.
Okay. And Mr. Myers, is this your case?
It is, Your Honor.
Are you ready for trial?
The people also are announcing ready for trial.
For the prosecution, any pretrial issues that we need to take up?
Just one thing from the people, Your Honor. I'm not sure if it's a pretrial issue. From what I'm seeing, I'm not 100% sure if Andrew has come to our office to pick up discovery yet. And so I just wanted to get kind of an update on that. We can give him the sheet again today just so that we're not there the morning of trial, kind of showing the discovery in the case.
I just want to make sure that I've done a full Arguello advisement as well, because I think we had... All right, I don't think I have, so I'm just going to make sure, Andrew, that you understand. This is an advisement I'm required to give if someone decides to represent themselves, and so I just want to make sure that the record's clear. All right. That you are making a choice to represent yourself. So do you understand that you have a right to represent, be represented by counsel throughout this case?
I've been told that.
Well, thank you very much.
As far as the benefit or firsthand knowledge of communicating with any legal professionals on the matter, I really don't have experience on the matter to speak and say, yeah, I understand what that would. But I don't want to cause controversy, and I don't want to be belligerent or cause dishonor in your courtroom. And I hope that because we've all known each other firsthand since July 1st of last year, I hope that I haven't done that ever in your courtroom.
Okay, so I have some questions under the law I have to ask, so I just need to make sure that the record's clear. So do you understand that if you cannot afford an attorney, then one could be provided to you free of charge? Do you understand that? So that would be the public defender?
Okay, I comprehend that.
Okay. And so the process for applying to public defender would be you'd go over to their office, you'd fill out an application, they'd say if you make below a certain amount, then you could have that attorney appointed. Do you understand that?
Someone like Miss Alika Johnston.
Johnston, yeah. She works for the public defender's office.
Absolutely.
Okay. And so these are just questions I have to ask under the law. So I'm not trying to quiz you, but do you have any legal training?
For did I go to law school or?
Yeah.
Every time I hear people say things like that, I can't help but think, if someone has no formal legal education or training, why do they speak as if they fully understand the law? It feels very similar to a situation in medicine. Imagine someone needing a serious operation, asking themselves if they should just do it without any medical background. They would likely say no, because they are not trained for it. So then the question becomes, why would anyone try to handle something as complex as a court case on their own when they are not qualified? Legal systems are complicated, just like surgery is in medicine, and both usually require proper experts to avoid serious mistakes.
The maximum sentence of a year in jail, $1,000 fine. There is a mandatory minimum fine depending on how many priors you have. It's either $500 mandatory minimum fine or $1,000 mandatory minimum fine, although the court can half those mandatory minimum fines if you provide proof of current insurance. Driving under suspension is a traffic infraction, and as well as expired license plates. So you're facing up to $100 fine on those cases. Do you understand the possible penalties that you're facing?
what you're telling me.
Okay. How far have you gone in school?
Away.
All the way?
Away.
Do you mean you graduated from?
Public school?
Yeah, just how far have you gone in school?
Well, before 2020, I was known as a master electrician. So I had completed, some stuff with Emily Griffith and had even a license as a master electrician, and was at that time, purporting myself to be an electrical contractor.
Okay. So did you graduate from high school
I
or
have,
get your GED
I have
or
a diploma from.
you have a diploma from your high school? Okay. And then Emily Griffith, for the record, is a trade school, but can also have like a secondary school beyond high school.
Right.
Sorry. Okay. All right. And then are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
I am not.
Okay. Do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Criminal law. Is this criminal case?
This is a criminal case.
Okay. I comprehend that.
Okay. And do you understand that you have a right to remain silent and that anything you say can be used against you in court?
I do not understand that because I was compelled to participate in the competency evaluation, and when they said they called, and I really have honest phone records from Comcast whether anyone called or left a voicemail, and they didn't call the number that we provided them, and I went to jail for that for 3 days because I didn't want it to. I wanted to remain silent and not testify against myself, but they contracted a psychologist from Canada who works on a case-by-case basis, and she basically, made me uncomfortable and threatened me and said if I'd already gone to jail for 3 days because somebody said they left a voicemail, and I didn't want to testify against myself. So as far as the right to remain silent with someone threatening me to go back to jail with like a gun in my head, I am forced to go against.
Some people may choose to believe they are not required to follow the laws of the state of Colorado. That is their personal opinion, and they are free to hold it. However, the situation changes once those beliefs are expressed through actions in public. In real life, every action has results, and the legal system responds based on behavior, not just personal views. When someone steps outside the rules that apply to everyone, they often learn that consequences naturally follow. Understanding this helps people see how society stays organized and why laws are enforced equally for all. It shows that shared rules exist so communities can function safely and predictably for everyone involved. Overall,
What will happen is if you make statements, the jury can take that in consideration of what statements you're making. So during trial, if you have an opportunity to testify, and we'll talk about that in the middle of trial once there's that time for any defense case. But any statements you make in court in front of the jury, those could be used against you. Do you understand?
And I really didn't come here today either to make any statements. I didn't know that we were going to have questioning like this.
Yeah.
Where I'm still, all these questions that you're asking me, I'm answering them under duress.
Okay.
Because while I'm supposed to be downstairs with Judge Gorman 7 minutes ago over the exact same stuff, and I've already done some time, and I don't want to cause dishonor. I don't want to cause controversy. I am seeking to correct my status, and I'm here by special appearance. I don't know what a fashion plea is, and last time I was with you, I was going to ask, you said a word to me if I found anything, and you used this word, and I was about to ask you what that word was or what it meant, and then that's when Mr. Myers approached me with the discovery. And so I was still trying to focus on what we were talking about or what you were saying. Do you remember what that word was? It was about if I found anything in the time that when we'd last seen each other. And I think the word started with the D.
There was also mention of a scheduling conflict involving another judge, which added to the confusion during the process. The person said they were trying to correct their legal status and appear under what they called a special appearance. They also seemed unsure about a term that was previously used in court, which caused further misunderstanding. Overall, the hearing continued with some uncertainty and clarification needed.
It was like a question, but it was you were saying, I trust that you didn't find any. And
I don't remember what I said,
And
but
then that's right when Ian came up to me and
so let me just ask you these questions then. So it sounds like you understand that at trial, if you decide to speak, that those words can be used against you. These are questions I'm required to ask because you're representing yourself, and I'll talk about the process for trial. But you should understand that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. And so do you understand that you have a right to confront the witnesses against you and cross-examine them? So in trial, the way that would work is if the prosecution calls a witness to testify, that person would get sworn in, the prosecution would ask those people questions, and then they would sit down, and their direct examination would end. That would be an opportunity then to cross-examine them or ask questions. So you don't have to cross-examine someone. The burden of proof is on the prosecution, which means that they have to prove this case beyond a reasonable doubt. You're not required to ask questions, but you do have a right to ask questions of those witnesses.
I could depose these witnesses, basically.
Well, we don't use the term depose, but you can ask them questions. Okay. And so you can ask them questions under the law as part of the trial. Do you understand that? Okay. And do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? So if you believe that someone, you'd like to bring in a witness, I'm not sure if there was anyone there with you on that day, but if there's someone that would come voluntarily, you can just ask them to come in and they could testify on your behalf. If you want someone to receive a court order, there is a process that you would go in. You'd file something with the clerk's office asking me to approve those subpoenas. If I approve them, then you would have someone not related to the case serve them. So you could have a private process server or the sheriff's office serve them and say, this is a court order to come to my trial. You could also have a third party not related to the case serve those people and ask that they be here. So do you understand that you have the right to have witnesses you choose court ordered to be here and testify on your behalf?
What do you think the likelihood would be of us summoning the Attorney General of the state of Colorado or the Registrar General of the state of Colorado, if that's relevant to the ultimate facts that got me to make the mistake?
The person explained that they were not expecting to be questioned and felt a lot of pressure while giving answers. They also mentioned there was a scheduling issue involving another judge, which added to the confusion during the process. They said they were trying to correct their status and appear under what they called a special appearance. They also seemed confused about a previous term used in court, which led to further misunderstanding. The situation showed how unclear communication and unexpected questioning made it difficult for the person to respond clearly throughout the hearing. Overall, the person was attempting to explain their position while dealing with confusion and court procedure.
Then, because you're not represented by an attorney can issue those subpoenas, but because you're representing yourself, you have to file something with the court, make grounds as to why you believe that the court should approve that subpoena. And so I would say I've never seen the Attorney General for Colorado come in and testify on a traffic case. You can always file something in writing and I can take a look at it. And let me just correct the record. Okay, go ahead.
Can I do that as the authorized representative of Andrew Lawrence?
I know that you are appearing today as if you are representing you're the authorized representative.
I'm here making a special appearance. I've come here to do that.
So you can file whatever you'd like if you believe that someone can support your case, and then I'll file something in writing. That's the cleanest way to do that. I just want to clarify, I guess I said it was driving under restraint, but you're charged with driving without a valid driver's license. And let me just confirm that.
I was wondering if that was appealed to something different
Okay.
when Mr. Myers came up at our last meeting.
They need to file something in writing then. So you're moving to amend the no valid operator's license?
Your Honor, if the court wants me to write a written motion, I can totally do that.
Okay. So
The judge explained the person's right to speak during the court process and noted that anything said in court may later be used as evidence. They described how cross-examination works, where each side can question witnesses, and clarified that the prosecution must prove the case. It was also explained that self-representation is allowed, but it can be difficult and carries risks. The person may still call witnesses and request subpoenas through proper court procedures. There was discussion about possibly involving officials, such as the Attorney General, if their testimony or documents were needed. Overall, the court outlined the basic rules of participation and evidence.
currently you're charged with driving under restraint. The prosecution is moving to amend it to driving without a valid driver's license. So driving under restraint means that your license has been suspended. What this charge is that they're moving to amend is to driving without a valid driver's license, which is a different charge. Do you have a position on that motion?
I haven't been offered a plea as
Okay.
far as making a decision on it.
Okay. So that no valid operator's license comes with a maximum sentence of a $300 fine, 90 days in jail. That's the maximum sentence. So I just want to explain to you kind of what you're facing, and then we've gone through that long advisement about representing yourself. Based on my advisement, do you still wish to represent yourself?
I'm not sure of the legal implications of me using the word myself. You know, and when I'm looking at pro se, it's is it he speaks for himself?
So are you making a knowing decision to not use an attorney in this case?
Based on what the
I would say the chance of obtaining a subpoena for the Attorney General of Colorado is extremely low and realistically very unlikely to occur. Such requests are rarely approved because they require strong legal grounds and proper relevance to the case. The court follows strict procedures, and not every request for high-ranking officials is granted. In most situations, only necessary and directly related witnesses are considered. Therefore, this type of subpoena would almost certainly not move forward under normal court standards. Requests involving senior government officials usually require very specific justification and clear legal necessity before any consideration. In most cases, it is not granted.
To, as I deem it, represent yourself because you're not using the public defender, you're not hiring an attorney, is made knowingly, voluntarily, and intelligently after a full advisal of your rights that you have in this matter. I've explained how to have a subpoena based on my observations of Andrew. I make a determination that he, based on his demeanor today, he does understand everything that I've just advised him of. And so I will find the waiver of counsel been made knowingly, voluntarily, and intelligently. So the prosecution has said you have not picked up discovery, which is the evidence in the case. So we can give you information to do that, but so that there aren't any surprises on the day of trial, you should go there today to pick up that discovery and make sure that you have that so that you're prepared, okay?
Okay. I do have another case.
In front of Judge Goman, yeah. We let them know that you'll be late.
If anything goes wrong in there, how would I get the discovery? Say I was put in the dungeon?
File something with the court, and then we can talk about it on the day of trial. So I'm going to explain to you the way that trial works. And so the morning of trial, what will happen is we'll check in with everyone to see if they're ready. I would suggest that you watch a trial beforehand. I do have a trial that I believe is going on this Thursday, so you can either come in and watch. I usually live stream my trials unless the defense objects, which means that you could log in and watch the trial. So then when we're ready, the jury will come in. We'll have 12 people that will sit in the jury box, and then we will have some extra people that will sit behind the prosecution. We will ask questions, preliminary questions of everyone that are legal ways that they could get kicked off the jury. For example, we can't have someone that's a police officer serving on our jury because of the charges. So then we have and ask questions of everyone. And then we will ask questions of the 12 people individually. I ask questions of everyone, and then I turn it over to the prosecution. They have 15 minutes to ask questions of the jury to see if they're a good fit for the jury, and then you will have 15 minutes. You don't have to ask them questions, but everyone gets equal amount of time. After that point, I'll ask if there's any challenges for cause. What challenges for cause are whether you believe that under the law, this person cannot be fair. And so there have to be legal reasons for them to not serve on our jury. Once we decide the challenges for cause, if anyone is dismissed for a challenge for cause, the extra jurors that we have in the back will sit in that person's seat. And then we do what's called peremptory challenges, which means that each side gets three people that...
Some passages in Scripture warn about leaders who create heavy burdens for others, saying, "Woe to you lawyers, for you load people with burdens hard to bear." This is often understood as a reference to religious teachers or lawmakers who made rules difficult for ordinary people to follow. Sometimes for their own advantage, they at the same time. Other parts of the Bible present a different idea. In 1 John 2 verse 1, Jesus is described as an advocate for those who make mistakes. In the original Greek, the word used can be understood as someone who stands beside another as a helper or legal supporter.